three individuals who are affiliated with the Administrative Conference of the United States, which is an independent federal agency charged with recommending improvements in administrative practice and procedure. So, for the most part, the ACUS is charged with the role of promoting efficiency, participation, and fairness in the administration of federal programs and regulations through the design of innovative administrative methods and study of the consequences of federal regulation. For this special event, we're going to have two presentations. The first, to summarize very quickly, is pretty much on ways in which we can harness the power of data to help government understand the effects of regulation and that's going to be by Todd Rubin and Reeve Bull.
And Carrie Collianese as well.
Yeah, and then and Carrie's going to contribute to the first one as well. Sorry about that. And for the second presentation, it's going to be Carrie Collianese. He's going to be presenting his work on regulation by robot, which explores the implications of machine learning and AI for public administration and for regulation as well. So to give a brief summary of some of our participants, our speakers, Reeve Bull is the research director of the Administrative Conference of the U.S. Reeve has worked on projects related to international regulatory cooperation, use of science by administrative agencies, presidential review of agency rulemaking, cost-benefit analysis, e-rulemaking, and amongst other things. Carrie Collianese is the Edward B. Shills Professor of Law and Professor of Political Science at the University of Pennsylvania, where he serves as the director of the Penn Program on Regulation and has served as a law school's Deputy Dean for Academic Affairs. He specializes in the study of regulation and regulatory processes with an emphasis on the empirical evaluation of alternative regulatory strategies and the role of public participation, negotiation, and business-government relations in policymaking. Todd Rubin is an attorney advisor at the ACUS. Before joining the organization, Todd was a lawyer at the U.S. Department of Education, where he worked in the Office of the General Counsel on the department's regulatory agenda. Thank you so much for being here.
Thank you, Jason. So, as Jason mentioned, the focus of our presentations will be on regulation. But before we get into that, I think it's probably useful to discuss very briefly different ways agencies make policy, just to situate regulation in the wider context of agency policymaking. So, among other things, agencies issue billions of dollars in grants and contracts every year to further certain missions, social welfare missions, for example. They issue decisions on licensing and permitting that can affect the construction of large interstate infrastructure projects, which obviously has tremendous public policy and economic implications. And they engage in adjudication. Everything ranging from small-time disability and veterans benefits to large, complex civil rights cases involving schools. And of course, they regulate. So regulation is a part of their policymaking. It's a very large and important part of it, and it touches on almost every aspect of our lives. If you look at the Federal Register, the Code of Federal Regulations, you'll see nearly every subject matter covered by regulation. So they're extremely important. I'm going to just briefly discuss the process of regulatory formation, how agencies go about issuing regulations, and some of the analytical requirements that they have to include in their regulations. There's no way I could do justice to the entire process. It's long, complex. There are nuances, exceptions to the exceptions. If you want to get a real sort of good sense of how the regulatory process works, I would suggest consulting a treatise. Actually, Jeff Lubbers has a book called A Guide to Agency Rulemaking, which is a very good place to start. Just in general, the first step is agencies have to act pursuant to authority from Congress. Sometimes they are required to issue regulations, so they do not have discretion. Sometimes it's discretionary, so they're authorized to, but they don't have to. But they need authority. Assuming they have that authority, they will then start off by considering the problem that assuming it's sort of discretionary authority, they'll start by considering a social problem or a market failure that they're trying to address through regulation. And they'll look at alternatives to regulation, other approaches that don't involve regulatory coercion. And they'll also look at whether they can amend existing regulations to accomplish the aim, or do they need to issue an entirely new one. So that's sort of the first stage. Assuming that they go forward with regulation, then they draft what's called a notice of proposed rulemaking, or an NPRM. The notice will have both a preamble and a text of the rule. The preamble is where you'll see the agency's analysis. So different executive orders and statutes require different kinds of analyses for rules that, generally speaking, for rules that are expected to lead to $100 million or more worth of economic impact a year. Agencies have to perform a formal cost-benefit analysis and include that analysis in the preamble of the rule. Sometimes agencies have more specific analytical requirements, so they'll have to look at the effects on specific sectors of the economy, like small businesses or American Indian tribes. They'll have to look, for example, sometimes at the environmental impacts on children. All of that will be in the preamble in the NPRM. Once they have developed the NPRM, they then generally have to send it to the Office of Information Regulatory Affairs, OIRA. Just how many people here, I know Ed's very familiar with OIRA, how many people here are familiar with OIRA generally and what they do? All right, so they are a component of the White House Office of Management and Budget. Their primary responsibility is to review regulations that agencies issue before they are finalized. They also have other responsibilities like setting privacy and statistical policy across the government. So the agency will send it to OIRA. OIRA, in the best case scenario, will send it back to the agency and say, go forth and publish. That almost never happens. OIRA have comments about the analysis. They'll review the cost-benefit analysis. They also serve this sort of function as a clearinghouse for other agencies to express their opinions on the rule. So if EPA issues a rule that has an effect on the Department of Interior's programs, and then DOI might have comments. So OIRA kind of compiles them all, sends it back to the agency, and there's this sort of back-and-forth process. Once OIRA and the agency come to agreement, then the agency can publish that NPRM in the Federal Register. The Federal Register is a daily sort of digest of federal regulatory actions. Once something is in the Federal Register as an NPRM, any member of the public can comment on it through a web portal called regulations.gov. Comment period can be set at 30 days, 60 days, sometimes longer. During which the agency is supposed to be considering comments. It's not a plebiscite. It's not a vote. The point is agencies are supposed to be able to get information that they otherwise wouldn't have from experts in the public. Once that comment period closes, the agency considers the comments and begins the process of drafting the final rule. And then, here we see the sort of a similar process. Once they have a final rule draft, they will submit that to OIRA again. OIRA will review it, make sure that the agency has addressed comments. If there are further questions from other agencies, the issuing agency should address those as well. And then finally, once the agency and OIRA come to agreement on the final rule text, it gets published in the Federal Register, and at the same time sent to Congress under the Congressional Review Act. Congress has 60 legislative days. If they want to disapprove of the regulation to act, they can issue what's called a resolution of disapproval. If Congress passes that and it's signed by the president, then the rule can be overturned. If Congress doesn't act within 60 legislative days, they don't need to actually approve the regulation. If they don't act, then they've sort of lost their opportunity to overturn it, and the rule is in effect. So that's the general process. A couple other things to note. There's also a retrospective review requirement. So executive orders 12866, 12563 require agencies to periodically reassess their rules. So you have to do a cost-benefit analysis before the rule goes into effect. Well, once the rule's in effect, how accurate were the agency's predictions? Additionally, under the Trump administration, there are two executive orders that are sort of game changers for the regulatory process. One is agencies have to, if they're issuing a new what's called a significant regulatory action, they then have to identify two existing rules already on the books to eliminate. Secondly, each agency is allotted a regulatory cost cap every year. Most of the time, that will either be zero or a negative cost cap. So if it's zero, that means for every dollar of new regulatory costs that an agency imposes on the public, they have to identify a dollar to offset that from their existing regulations, and to do that by appealing to existing regulations. If an agency has a negative cost cap, then they have to find savings from existing regulations, even if they're not issuing a new regulation. So and that's one of the major new requirements. Another one is the establishment of these regulatory review panels that each agency is supposed to go back, look at the agency's regulations, see which are duplicative or redundant, unnecessary, and then repeal them as necessary. So that's the general process and some of the analytical requirements involved. Now, if you sort of step back and take a look at both the process and the analytical side, you see the seedlings of what we might call evidence-based regulation. The reason I wouldn't go so far as to call the existing structure evidence-based is because there hasn't yet been some federal directive that ties them all together into a cohesive framework or protocol that you see in, for example, scientific research. So you have a couple of recommendations before you from ACUS, which sort of takes all of these existing analytical requirements and sort of starts a discussion of how agencies can go about beginning an evidence-based regulatory framework. Additionally, Carrie and I wrote an essay that was published a few months ago in the Reg Review, which encourages agencies to think of their regulatory process as scientists think of their research process, or in the case of the essay we wrote, the process for developing medical treatments, pharmaceuticals. So in pharmaceutical treatment, or development of pharmaceutical treatments, you have a research and discovery phase where researchers are considering various alternatives and sort of coming up with theoretical bases for why a particular medicine may work. They're doing some testing in animals and cells. And then once a promising treatment emerges from that phase, they begin to plan for clinical trials. They don't actually start a clinical trial, of course, until they've developed a protocol that's approved by the FDA. The protocol has to lay out a hypothesis, identify how a treatment and control group are defined, whether the control group is going to be a placebo group or the standard treatment versus a new treatment, and then how often are they going to assess the results? What frequency are they going to use? Every month or 2 months or whatever. And then, of course, once they've developed this protocol, then they can begin testing the medication in humans. Well, we think of regulation as a similar type of test in that an agency can't possibly know how a regulation is going to affect society until it's put in place. So we think it makes sense for agencies to think about a similar protocol before they impose a regulation on society. They can, in this protocol, they can develop a hypothesis, and sometimes that might be a benefit-cost analysis, or it could be a more specific question about how this regulation affects a certain industry. And then they identify a treatment and control group, which could be the world or American society before the rule went into place and after the rule went into place. Occasionally, there might be circumstances where they can use a randomized control trial approach to regulation, and Carrie will discuss some of the advantages and disadvantages and legal issues in those kinds of approaches. So agencies can use quasi-experimental and experimental approaches in implementing regulations. And then, of course, how is an agency, what data is the agency going to collect, and how is it going to analyze that data to see whether the regulation is working as it expected it to, and the frequency by which the agency will go back and assess its regulation. So in thinking about this protocol approach, agencies are taking the retrospective review requirement and essentially planning for it before the rule goes into effect, rather than let's put the rule into effect and at some point in the future assess how effective this rule is. It's sort of evidence-based regulation refers to planning for that retrospective review at the outset. So I guess I'll turn it over now to Carrie to go into some more details about this kind of evidence-based framework for regulation.
Great. I guess at the outset, let me ask if anybody has any questions for Todd or that we can answer about some of the background information that he just provided. It might be worth pausing for a moment if anybody does have a question.
It sounds like randomized trials would be pretty hard here, right? Is it mostly going to be before and after? Right? Because I imagine if you impose more stringent rules on one location that's not too far from another location, people are just going to go to that other location and do whatever they want to do. So if that's the case and you can't do many randomized trials, how do you control for external factors before and after? Right.
So I think you put your finger on an important concern. It's not just that with randomization, people might, game the things if they know it, but also when we developed this recommendation that Todd was referring to at the administrative conference, and I guess at the outset I should say I chaired the rulemaking committee. I'm not a member of the government. I guess I'm technically a special government employee or something along those lines. But they're really from the government and here to help you, not me. But Todd staffed this effort, and Reeve is overall in charge of the research that goes on at the administrative conference. And as part of developing this recommendation, we had a committee that fleshed out a proposed recommendation, and then that was taken to the full floor of the full conference, which is 100 or so. Both public members and government officials who vote on approving this. And I'm mentioning all that because it really didn't come up a whole lot of concern about the kinds of methodological issues or inferential challenges to randomization and the gaming that might occur. But there was a lot of concern about the ethical aspects. How do we, especially if we think a regulation is delivering safety, do we let some people go on airplanes with some safety rules and other people can go on airplanes without those safety rules? So that was, I think, the chief concern about randomization. And I think it will clearly limit the number of instances where this can be used. Let me say, first of all, I think that there are places that still could be used and probably don't raise those kind of concerns. And one of the paradigmatic examples that Michael Abramowitz and Ian Ayres give in a paper that, if you're interested, they call Randomizing Law. That's the title of the paper. They say maybe with respect to, say, traffic laws, where people they can't really game the system, and you just choose certain roads at random to place certain rules, and other roads randomly, other kinds of rules. So you could imagine in some contexts it's hard to game it, and there's probably not a huge equal protection kind of concern, possibly. But there's probably going to be few and far between. So then the question is, how do you do this? And you have to, with before and after, you have to ideally get some kind of control group where this isn't in place. So you could, if you can take advantage of regional variation as well, you do a differences in differences type of strategy, or you can take advantage of more like regression discontinuity designs and try to take a look at what's happening, right before and right after. Event study kind of framework might be plausible as well. But one of the things that's unique about this recommendation that Todd was developing, and you have here called Learning from Regulatory Experience, is that the actual recommendation that ACUS has issued here is 1 page long, 5 recommendations, and I will characterize it this way. It won't be an official characterization. Nothing I say should be deemed as official to ACUS at all. But these are pretty plain vanilla kinds of recommendations. Agencies should do a good job of analyzing their data. And what's unusual about this recommendation is that those are so short and plain vanilla, and the preamble, which is all the part that comes before it, is much longer than a typical ACUS preamble. And in that preamble, what we're trying to do there is distill for agency lawyers a little bit about how to think about confounding factors when trying to assess whether a regulation is working well or not. And it's for anybody who has any social science training, any econometrics or the like, it'll be really too simple. But for a lot of agency lawyers, we were told that even this might be a little challenging for them. So anyway, other questions?
Yeah, just following up on that. This idea of regulatory experimentation is very fascinating to me.
Yeah.
Someone who studied causal inference and did his thesis on causal inference methods for social science research. And I'm kind of thinking about the ways in which a kind of experimental framework, like a clinical trial framework, can be used to roll out regulations and try to figure out their effects. And of course, the ideal model, from my perspective, would be one in which, let's say, a regulation is supposed to take effect on some certain date, but prior to that, out of a pool of municipalities, let's say, there's a group that's randomly selected, and then the other group serves essentially as a control, and you measure some outcome for that group that was randomly selected over some period of time. And so I guess my question is, given that would be, let's say, the gold standard of causal inference, is something like that actually possible to do at some point? And the second question is, in what domains do you think an ideal strategy like that might actually work and also satisfy a lot of the ethical concerns that might arise out of such a future?
Yeah, I think what we do in the recommendation is divide the rulemaking process to before the rule's put in place, designing the rule itself to afford an opportunity perhaps for that kind of either if randomized learning or other kinds of observational assessments, and then learning after the fact. And the clearest room for the gold standard is before the rule's put into place. And I'll give you an actual example of a setting where this has happened, and in fact it's emblematic of a number of different areas where this happens. Back when the federal government was thinking about putting in place passive restraints for automobile safety protection, they actually did engaged in some voluntary agreements with big companies to randomly put different kinds of safety devices into their corporate fleets. And there was there's no question about we're randomly assigning the law at all, but we're randomly assigning different safety interventions that we might want to put into the law for all cars, and we did that on a voluntary basis with a large fleet. So I think that is the clearest and easiest domain in which an agency, before they're thinking about going in and making a new rule that will apply across the board, try to find some places where we can experiment ahead of time. In terms of later on, then it gets a little bit more challenging. It is possible to design rules to allow for some kind of variation. Brandeis had this famous quote about states as being laboratories of democracy, and there may be ways to allow some regional variation or some temporal variation, so that a rule takes effect in certain domains, jurisdictions, certain states before others, and to try to exploit the variation there. It wouldn't be quite that gold standard, but it would be a way of thinking about designing a regulation that would facilitate learning by building in some opportunities for there to be variation. And then after the rule takes effect, I think there's opportunities for thinking experimentally about the enforcement and the implementation of that rule too. That doesn't really, I don't think, give rise to the same kinds of concerns about randomly assigning people different legal obligations, but we could think about randomization of ways of different ways of enforcing or inspecting facilities. So I think one of the things that, and I guess to just move this a little bit forward, and I think there will be other time for further questions, but one of the values I think from this particular recommendation and thinking about systematic ways of making causal inferences about the impacts of rules is that it focuses agencies' attention to doing what you do here at Princeton all the time and with your students is learning. And yet, what's remarkable to me is that we have had in every administration since Carter an initiative calling on regulatory agencies to look back at their existing rules and see which ones can be put to rest and which ones can be eliminating costs. And are you going to talk some more about retrospective review?
Yes.
All right. Well, let me just so Reeve's going to talk a little bit more about it, but maybe I'll come in a little bit later on that. But I think most of those initiatives all focus on looking back at rules to try to reduce burdens and reduce costs. And a learning framework along the lines of this recommendation, I think, shifts beyond that and says it's not just a matter of looking back at regulations to try to eliminate the bad ones, but maybe also learn which ones were good and why. And this takes a much more strategic approach to retrospective review. The other thing that's distinctive about this, I think, is that it is calling upon agencies when they do look back at rules to try to do so in a rigorous way. The Obama administration, much to its credit, joined many other previous administrations in having a look-back initiative. And one of the objectives of the Obama administration was to try to build a culture of evaluation into the regulatory sphere in the federal government. I don't know how well that culture is going to last, but that was the intent. However, when one looks at the actual rules that were part of the Obama administration's look-back initiative, most of the assessments were expert-driven and not research-driven, and certainly not causally based or inferential research driven. A lot of these, and I have actually randomly sampled a large sample of rules and found that most of these just involved committees sitting around a table saying, does this work? What do we think the problems might be? And so forth. And there's some value to that. I don't want to dismiss it, but it's still very limited in what you can do. And it also meant that most of the changes that occurred as a result of the Obama retrospective review initiative were largely in the area of reducing administrative costs, eliminating paper forms and moving to electronic forms. And again, I don't want to dismiss that either. There's a lot of paperwork, and anything one can do to streamline paperwork is a good idea as well. But it's also very limited to just sort of this low-hanging fruit of administrative burdens and not really getting at the fundamentals of what problems the regulations were designed to solve and whether they're solving them or not. So I guess that's what I'll say about what I think is distinctive about this particular recommendation. It is both aiming at learning about costs as well as benefits, and learning in a way that's trying to promote agencies to think causally about what their regulations really are doing. So with that, I'll turn, I guess, over to Reeve to talk more about retrospective review.
Okay, excellent. Thanks, Carrie, and thank you all for the opportunity to come and speak with you. So what I would like to do, and I guess the final segment of the presentation is build on this idea of retrospective review, how agencies go back and revisit the regulations, the rules that they currently have on the books. And as I think Carrie's presentation very excellently laid out, the ideal here, I think, with respect to regulation more broadly, is to move more towards an empirical approach where you're planning for revisiting the regulation at the very outset, and you're trying to build an opportunity for experimentation into the policy itself. and that indeed, as Carrie pointed out, once you have a regulation in place, you continue to look for ways to use things like waivers and exemptions or other opportunities to look at variation that naturally occurs and try to improve the policies over time. So that was really the focus of the more recent recommendation on regulatory learning. We had a previous recommendation in 2014 that was focused specifically on the problem of retrospective review. And as Carrie, I think, very nicely points out, this is a huge problem for agencies. I mean, as Carrie mentioned, there are initiatives going all the way back to President Jimmy Carter, where in every single instance, the president would come in and say to the agencies, go back, revisit the rules that you already have on the books, try to figure out what's working well, what isn't, and try to modify the regulations or rescind the regulations if they're not working in a way that optimizes them in light of the existing reality. But there really have been pretty limited successes. You know, as Carrie points out, a lot of it was limited to pretty low-hanging fruit, you know, paperwork burdens, or in some instances, there were rules that the agencies were already sort of in the process of rescinding, and, you know, they actually took advantage of this retrospective review initiative to clear some of those rules out. But the impact has been pretty modest, pretty limited overall. And I think that that's true for a number of reasons. I think first, there's a huge resource problem here. You know, the agencies over the course of the last multiple decades have issued thousands and thousands of regulations. And to tell an agency, even a single agency, to go back and look at everything you have on the books is really a very challenging thing to do. So just by way of comparison, Todd mentioned the OIRA process. And OIRA is responsible for reviewing every significant regulatory action, every new regulatory action or significant regulatory action that's issued. And of those, about 2 to 3% are what are called economically significant regulations. I might not have the percentage quite right, but it's relatively small. And those are the only ones that are actually subject to a full benefit cost analysis. So you're talking about only the tip of the iceberg in terms of rules that are actually undergoing a rigorous regulatory impact analysis. And that's just for new rules. That takes no account of the thousands and thousands of regulations that you already have on the books. So I think that's one of the major issues here. Is it's a huge resource problem. Secondly, I think there's also a siloing problem. So each of these past retrospective review initiatives, from Carter through Obama, the individual agencies themselves were tasked with revisiting their own rules. So any given agency probably has a pretty good sense of the overall stock of regulations it has and how those regulations might interact with other regulations, but it doesn't necessarily have a good sense of what other agencies are doing and how its rules might articulate with those of other agencies. And if you're a regulated entity or a member of the public, that's really all you care about is the overall regulatory burden. You don't necessarily care about what any individual agency is doing. But those individual agencies are not necessarily well positioned to do that type of analysis. And then finally, and you know, this is something that I briefly written on. You have what in the behavioral economics literature is called the Ikea Effect, where if you've ever purchased something from Ikea, you know it's a box of wood basically, and you're responsible for assembling the entire thing. And these behavioral economic studies have showed that if you actually design something yourself, if you actually build it yourself, you value it more highly than what somebody else might value a similar object. And I think you can apply this in the regulatory context in the sense that if you design the rules yourselves, or even if it's an older rule, if you've invested a significant amount of time in learning this process and internalizing these rules, you're going to be just psychologically somewhat reluctant to upset your own handiwork. So to me, that's another limitation of having the individual agencies do the retrospective review. So those are some problems with it. I would say, on the other hand, though, that it's the individual agencies that actually have the expertise and actually have the knowledge as to how these regulations work. So you can certainly conceptualize a separate process where you vest that authority for retrospective review in some separate entity, but it's not going to have the same intimate knowledge of the rules that an individual agency would. So that has some drawbacks as well. So what I'd like to do just briefly is go through what I conceive of some possible solutions to this problem, and I think that the conclusion that I'll reach is that none of these is really ideal. I think it's inherently a very, very difficult problem, and I think each of these has some promise, but it also has some drawbacks. So first, there's the approach that we basically take in the ACUS recommendation, 2014-5. And the idea there is basically that we're trying to push agencies towards establishing what we call a culture of retrospective review. So the OIRA process, the prospective regulatory analysis process, has existed for about the last 35 years or so. And in that time, the agencies have really taken this to heart. They all employ economists. Benefit cost analysis is a big part of their overall regulatory process, and that sort of factors into the thinking from the very outset. I think it's fair to say that's not true with retrospective review. And so what we're trying to do in the recommendation is sort of move the needle and sort of push agencies more in that direction. And there are a number of more specific recommendations that we make that we think would facilitate that process. So first, we urge them to plan for retrospective review from the very outset, actually write the rule in a way that it has clear metrics, that they clearly identify the sort of data that would be useful. And so as a consequence, over time, as the regulation is being enforced, stakeholders particularly know the sort of information that the agency is looking for to help them assess whether the rule is successful or not. So ideally, this would create a more interactive process between the agency and its major stakeholders, and they could learn over time whether the rule is working, and if not, how they might change it in a way that would make it more effective. Another major aspect of this is triaging the stock of existing regulations. So, for the resource reason I mentioned earlier, agencies are not going to be able to review every single regulation they have on the books. That's just completely impractical. They have to have some mechanism for identifying which regulations are good candidates for reanalysis and then prioritizing those regulations. So we highlight a handful of factors agencies might consider: rules that have particularly large economic cost, rules where the initial regulatory impact analysis was unclear, and where there may be some benefit to actually going back and reassessing it in light of additional information. If there's been a major technological change, those rules may be good candidates for reanalysis. Or if there's significant international divergence, that the way the U.S. is doing something is significantly different from how a major trading partner is doing it. Those might also be good candidates. So, I think that there's obviously some benefit to this, and I think it would be a very good thing if all agencies were to really take this to heart. But I don't think it necessarily solves all of the underlying problems, because both the Ikea Effect issue and the siloing issue I mentioned earlier would still be a problem here. It's still something that's undertaken by the individual agencies. And so they're not necessarily going to know how their regulations interact with those of sister agencies. So another possible approach, and one that I've explored briefly in the literature, is enhanced stakeholder input. So the agencies are going to have one perspective, and they're going to be coming at it from their individual agency's perspective. Stakeholders, by contrast, be they businesses or just members of the public, are much more interested in the cumulative regulatory burden. So they may be actually better positioned to, provide information that would be useful as agencies are undertaking this retrospective analysis. This could be something as simple as just soliciting comments, that individual members of the public could provide information to the agency and they could take that into account. Or it might be something more ambitious, like actually creating a petitioning process by which regulated entities could actually urge agencies to take an entirely different regulatory approach. Again, I think each of these has some promise, but it also has some drawback. With the notice and comment, agencies have actually done something somewhat similar to that, and the issue that arises is that people just sort of complain about regulations they don't like. They don't really take into account the benefits of the regulations. They're focused solely on the cost. And with respect to the idea of a petition for alternative regulatory treatment, you potentially have a capture problem. The major industry players are much better positioned to take advantage of a system like that. A possible third approach is trying to realign the underlying incentives for the agencies. The executive orders that Todd mentioned, the two Trump executive orders, basically try to do a version of that. So with both the 2-for-1 in the regulatory budget, basically they're changing the incentive structure in a way that the agency now has a very good reason to be policing its stock of regulations, because any time they want to do something new, they're going to have to identify 2 regulations to get rid of and a dollar-for-dollar offset, or maybe even more than that if they have a negative regulatory budget, to swap out for new regulations that they want to impose. There are also a number of pieces of legislation, the so-called Skrub Act and the Regulatory Improvement Act, that would actually put in place such a one-for-one initiative or dollar-for-dollar swap-out initiative. So this is something that's already being tried in the Trump administration, and there's some interest in Congress in perhaps institutionalizing this more permanently. Again, I think that this is perhaps attractive in some ways. It's relatively simple. It definitely changes the underlying incentives, but I think it has some major drawbacks. One, I think it only works well if there's a lot of slack in the system, if there's a lot of unnecessary regulatory costs that can easily be eliminated. Once you've eliminated that low-hanging fruit, then it starts to be more problematic. You might actually be cutting regulations that are clearly beneficial. And the focus is really solely on regulatory costs. They don't take into account the countervailing benefits that those regulations create. And in some cases, those benefits may actually be much larger than the regulatory cost. So the sole focus on cost is perhaps problematic, particularly in the longer term, where once the agency has eliminated the low-hanging fruits, then you may actually be cutting into regulations that really provide demonstrable benefits. The final approach, and I think in many ways this is the most ambitious, would be creating some sort of retrospective review commission, actually creating some separate entity that's responsible for doing retrospective review itself. The Trump executive orders do a very modest version of this. The second order, 13777, actually creates at each agency a commission or an in-house expert body that's basically responsible for looking at their rules and identifying those that might be good candidates for elimination or modification. There's also legislation currently being considered that would undertake a much more ambitious version of this. So the Skrub Act that I mentioned earlier would actually create a 9-person commission that would be responsible for reviewing the entire stock of regulations that are currently on the books and identifying those that are outmoded or should be rescinded, and then they would make a recommendation to Congress, and then Congress could actually pass a joint resolution that would get rid of those regulations. There's another bill, the Regulatory Improvement Act, that would do effectively the same thing. And then finally, you could actually take this perhaps even a step further and actually create something like a super agency, like an OIRA, that would actually be responsible for doing the retrospective review itself. I would see this as being the most ambitious, and I think also perhaps the most problematic, for the reason alluded to earlier, that Such a super agency would obviously be much more objective. You'd solve the siloing problem and the Ikea Effect problem, but it would not have a good understanding of sort of how the individual regulations actually work in practice, unless if it was staffed extensively by experts. So simply wouldn't have the subject matter expertise that the individual agencies do. So that's an array of options. It's by no means exhaustive, but I think these are sort of 4 possibilities one might consider. And as you can see, I mean, each of them, solves certain problems, but then it creates other problems as well. So I think at the end of the day, to be successful here is going to require sort of a similar approach to what we took in the more recent recommendation, and that's to focus on experimentation, basically. Much as with promulgating new rules, I think with retrospective review, you had to be willing to try different approaches. Some may work reasonably well in certain contexts, but not in others. And I think over time, hopefully we'll come to see, what works well and what doesn't. And I think in that sense, the Trump executive orders, whether you think of them as a good thing or a bad thing, this is a type of experiment. We're sort of seeing how this will play out. And a number of other countries are actually doing something very similar at the time. The UK, Canada, and Australia all have some sort of one-for-one swap-out initiative. So in a way, this is a type of experiment that we'll see whether this actually works and whether the benefits actually exceed the costs. But I think to really make some progress here, it's going to require agencies and Congress and the administration to be innovative and to constantly explore ways to move us closer to more of an empirical based policymaking system. So I'll conclude with that, and I guess open it up to questions for anybody on any of the portions of the presentation. Yes.
Thank you. I just had a quick idea. So I'm a lawyer, and I became interested in social science effects of law. And I found the social legal studies and empirical legal studies communities, who I think would be dying to work with agencies because it's a very growing field and it's looking for recognition. And I think if you could incentivize them to do some special issues of journals in their field, reviewing a few things of the administration, I think that could be a really good sort of match there.
No, I completely agree. I mean, I think they're really just sort of enormous untapped resources, and a number of scholars and schools that would be very interested in doing this sort of analysis, and I think the agencies could really benefit enormously from leveraging that expertise, and that's where, in particular, I think moving towards more of a system of prospective retrospective review, where the agencies are actually writing the rules in a way, anticipating the types of expertise and the types of information that would allow them to go back and reassess the rule would be very, very beneficial, because then it would allow, it would create a clearer target for, the types of information the agency can then use, and would allow them to sort of leverage this outside expertise in a way that I think for the most part they're not currently doing. So I completely agree with you. I think that's an enormous opportunity.
You talked about how there's sort of a new drive to both bake empirics directly into future policies and also look at empirics for retrospective review. I'm wondering, I don't really have context, just how new is this across agencies? Does that vary how much of a focus on empirics it is, or is it a very kind of new 2018 type thing?
Yeah, so it's a very good question. I think what's sort of perhaps new in 2018. I mean, I think with respect to sort of the prospective analysis, there's a relatively robust infrastructure in place, although I think that there's probably significant variation from agency to agency, largely I think it's partly cultural, but I think it's also partly because extent to which you can define the effects of the regulation in economic terms sort of varies from area to area. So I think, at least from our work, probably the Department of Transportation has done the best work by far in this area. And I think part of that is cultural. I mean, I think part of it is, very early on, they've had a strong commitment to prospective and retrospective analysis. But I think another part of it is it's much easier to actually define in that area what the effects of your regulation are. Either you're reducing highway traffic accidents or you're not, and that's a relatively straightforward metric. Whereas in other areas, in the environmental context or education or any number of areas, it's much harder to actually examine the outputs in a way, or the inputs and the outputs, such that you can, assign numbers to it and actually perform this sort of economic analysis.
Do you see places like the Department of Education moving away from, say, case study analysis towards more empirics, and just generally like places where there's less data to be had to be trying to move in that direction in a general push, or?
Todd was at the Department of Education prior to coming to ACUS. So did you want to
as we've mentioned, there are definitely cultural differences in agencies, and education has lagged behind, like the Department of Transportation, for example. There are, some notable exceptions to that, but in terms of regulation, education does not have a robust economic analysis or infrastructure set up. It actually does very much for grant programs and evaluating the success of interventions that it funds. It has the Institute for Education Sciences, for example, which is a very high quality program that uses empirical analysis. But for regulations, I don't see that particular agency kind of moving towards more an empirical model, and I think partly because of the nature of the enterprise. It's harder to quantify some of the benefits in education than it is in, for example, reducing traffic fatalities.
I think the other thing too, agencies have different tools associated with them, and a lot of what the Department of Education does in terms of regulating, quote unquote, really comes from the grant administration. That's right. That's a lot of their power. I want to, emphasize two things. One, you said, is this relatively new? I guess it depends on what it is. To paraphrase, Bill Clinton, but the demand for good analysis underlying regulation has been something that courts have expected since at least the early 1980s, through the exercise of their authority to review rules under the arbitrary and capricious test. That has really given rise to the need for agencies to justify what they're doing, and to the extent that we're talking about analysis at the very broadest level of providing reasons, looking at evidence, and so forth, I think there's been a strong tendency for agencies to need to do that since at least the early 80s. That said, what Reeve and Todd are saying about variation across the agencies is exactly right. You can look at, there's some work that Bob Hahn has done in which he looks at economic analyses that agencies have conducted in support of new regulations, and then just basically gone and compared them against a checklist of what should be in a good economic analysis using OMB's own guidelines for that checklist. And there's wide variation, and there are some agencies that do it better. EPA has built up a good economic analysis shop. The Department of Transportation certainly has too. So I think, but that's all good. In terms of analysis before regulation is put in place, that's not necessarily the same as what we were talking about in terms of empirical causal inference. That's always sort of looking back and trying to assess. And there, I think there's also variation across agencies. It's partly perhaps what Reeve and Todd said about culture, but I think it's also partly the nature of the problem and the availability of the data that the agencies are dealing with. So, as Reeve said, the problem of automobile accidents is pretty well operationalized and conceived. But there's also a great data reporting system. Every police report goes into the Department of Transportation, and they can analyze those data. When you're dealing with nuclear reactors melting down or other kinds of low probability but high consequence events, which a lot of regulation tries to deal with that, much harder to get an empirical assessment of things that just aren't happening that frequently. One of the ways you can do that, again, this comes out of the Department of Transportation, is to think about operationalizing systems for near-miss reporting. And so the Federal Aviation Administration has worked with NASA to develop a system where pilots and other airline personnel can anonymously or report near misses and other failures as a way of then getting larger data on the precursors to these rare events.
That being said, I think I'm going to jump in a little bit on this question of agency expertise, because this whole discussion takes me back to an experience with an ANPRM on connected vehicles, where I was sitting with OIRA as they were processing that in late 2016. And here it was a regulation that was motivated by vehicle safety. And the Department of Transportation and NHTSA, National Highway Traffic Safety Administration, had incredible expertise on those issues. But on the cost side of the equation, some of it was the cost of actually building equipment into vehicles, and DOT had done a fairly comprehensive job of estimating that. But there were a couple of other kinds of costs that were, I think, pretty clearly outside the agency expertise to think well about. One of them had to do with the use of spectrum, electromagnetic spectrum, because these would be radio signals from vehicle to vehicle, and it would require allocation of a bunch of spectrum, which then withholds that spectrum from other uses. And the other one was consumer privacy, that mandating that vehicles transmit certain information on a regular basis would lead to potential privacy risks for drivers and car owners. Again, something that was outside the expertise of the agency. And so there's a kind of risk that comes in when an agency is regulating for a benefit they understand well, but with costs they don't understand as well. And one of the things that I think the OIRA process was trying to do in a case like that is to bring in other expertise and make sure all of that was understood, right? So the FCC understands pretty well what the cost of spectrum is. Privacy is a little harder because the main expert agency there is probably the FTC, which is an independent agency, and that's complicated. But nonetheless, the agency expertise can be pretty uneven, and the risk of a blind spot there is one of the things that I think the OIRA process can help to deal with by bringing together that interagency input, as you talked about. And so this maybe suggests that a model that's closer to the OIRA role in regulation is something that might make sense in a retrospective setting as well, right? Where you have an agency that's doing the primary work of doing a retrospective analysis, but then you have some entity that is able to look at that and say, wait a minute, we need to reach out for this expertise over here, or I'm not sure you've nailed down that part. The other thing that OIRA sometimes did was to be methodology police on the agency's cost-benefit analysis, or the regulatory analysis that was done. One would hope that the kind of methodology of analysis that's used in proposing a regulation is always wonderful, and it usually is, but occasionally OIRA would play that role, just to be another set of eyes on the methodology.
So my reaction would be just to agree with you 100%. I think that's exactly right. I think OIRA, that's one of the main functions it can and should serve. Indeed, Cass Sunstein, when he left OIRA, wrote an article where he really emphasized that aspect of the process, that it's not just regulatory impact analyses. And a big part of what the agency is intended to do is bring together the otherwise siloed expertise in the government to work on these big problems. And I think going forward that's a very attractive model as well for the retrospective review. I think the biggest problem with it at the moment is if the agencies suffer from resource constraints, a fortiori OIRA. I mean, you're talking about literally a 5,000 to 1 ratio, I believe, in terms of the number of people at the agencies and the number of people at OIRA. And indeed, I think they currently have 50 people at OIRA. It was 100 when it was first created, so it's about half the size as it was originally, and is doing every bit as much, if not more, than what it was originally created to do. So I personally think that's a very attractive model, but I think it's going to require some real infusion of resources.
But I think this also means we've got to think more strategically about which rules to retrospectively review. And that, I hope, is where at least this recommendation maybe can move people forward. I don't think we're going to be able to do this for hundreds upon hundreds of rules, right? And we're maybe not even do it for every rule that's gone through OIRA review. But I think the process should, OIRA could be helpful in thinking strategically. And I think there's a couple of candidates for a strategic approach to retrospective review. Is one, I think rules that went through that were really significant, but where the benefits were maybe only slightly greater than the costs. These were what I might call kind of regulatory close calls. Those seem to me to be ones maybe where we should go back and look at those. Whereas if there's something wild, looks like getting lead out of gasoline was wildly successful in terms of public health benefits, I don't know that that's going to get us a whole lot to really rigorously review retrospectively, as much as something where maybe it was a close call. The other, where there are high levels of uncertainty, let's try to nail down those uncertainties. A third one would be where there's common issues across different regulatory spheres, and maybe it's in connected technology, Internet of Things world. Let's look at how we're doing in one sphere, and that may help us in other spheres. Or maybe that with these kind of low probability, high consequence events, that you can learn a lot for reducing chemical facility explosions by retrospectively reviewing nuclear reactors, for example. So that would, I think that we also need to have, and that might also be why an OIRA could be helpful, or an OIRA-like institution could be helpful.
It also seems like at the time that a regulation is being written, there may be aspects of it or particular decisions within the regulation that seem at higher risk of being wrong.
Right.
Or being wrong in hindsight. Right. And so it would be useful to designate those.
Yeah.
Or flag those somehow internally.
Yeah, I've suggested that agencies, when they're going through the OIRA process, should actually come up with some kind of a plan for retrospectively reviewing it. And that could flag those issues, could give some clarity about what really we see as the objectives to evaluate later on, what might be a good time frame. We're not really expecting this rule to have effects for 2 years, but 20 years down the road, that should be a good, those sorts of things could be thought through as part of the prospective analysis process.
Maybe that last point.
Yeah, just on setting the data points and variables to analyze. So I think there's a danger to be too conservative, especially if you're looking at fast-moving technologies.
Mm-hmm.
And I just want to talk about one experience I had in Europe when we were working on this copyright law review process, where the metrics that were set were how many CDs are being sold and how many unlawful copies of MP3s are being downloaded. This was like 6-7 years ago. And the problem with that is, or it seems to be that until the regulators let go of the idea of selling music as units, only then did they start to understand that licensing things like Spotify made sense, and then the market grew again. So you had the metrics, so the relationship of consumers to the technology and the object of regulation had changed. but the previous metrics were so tied to the previous technologies that the new technology, it took some persuading for the sort of mindset to change. So I think there's a danger there that, or there should be, as Ed says, there could be some external people who can sort of review the social impact of technology and vice versa, and what that means for the metrics.
Excellent point. Yeah.
Yeah, no, I completely agree. I think that sounds exactly right. And I guess sort of, to some extent, it's sort of an inherent problem to a regulatory process that, particularly in the United States, is so drawn out. It takes years and years to enact a new rule, and, in a rapidly technologically evolving area, that's a major challenge. But yeah, to the extent that you could sort of leverage the outside expertise to a greater extent, I think hopefully it would help, mitigate that issue, if not solve it completely.
Should probably let Carrie
Sure.
move into
Sure.
his presentation and set up. So we'll take a break for
Yeah, it was fascinating.
Carrie, you need the screen?
Yeah, I'm all set. Yeah. So you want me to should we get started? Okay, great. We thought as long as we were here, you wanted to hear a little bit about law and technology, and I thought I'd share with you what is now a published paper, Regulating by Robot, that's co-authored with David Lair, who's now a Yale law student, had been working for me at the Penn program on regulation previously. And this paper will, I think, focus much more on law still, but it's motivated by advances and developments in machine learning in particular. And I guess the way I want to just situate the paper first, position the paper, and then I'm going to talk about 4 areas of federal administrative law that lawyers in government might think of as potential barriers to the use of machine learning. My bottom line is going to be I don't think those barriers are there, or if they are, they're not insurmountable. And then I'll make some conclusions. But obviously, this is not the place I have to tell anybody about the potential for machine learning and its uses in making and supporting more accurate decisions, and the values that it is bringing right now in the private sector have been pretty remarkable, and the use is expanding in a widespread manner. But what about the potential applications in government, and what does that mean, particularly if the federal government were to start relying on machine learning in new areas? Is it going to run afoul of existing laws? Let me just situate this by pointing to a couple of examples where I have read about machine learning being used in the federal government, and you may all have many other examples as well. The U.S. Postal Service using it for handwriting recognition, very clear. The IRS for assisting in fraud detection. The Environmental Protection Agency has some research where they've tried to use machine learning to target chemicals that are potentially toxic, and rather than subjecting all these hundreds of chemicals to animal testing and so forth, which can be very expensive and time-consuming, can they get ahead of it by some forecasting through machine learning, and they're finding some positive results. The FDA similarly looking at predicting medical devices that may be failing. These are just some of the uses that are taking place in government, and the question might be, well, okay, how should lawyers begin to analyze and understand these uses when it comes to putting them in place in government? Particularly, I think there's two aspects of machine learning that have some implications for its application in government. One is the black box nature of it and the way it's not able to be converted into easy if-then formulations of reasons in the same way that conventional analysis has in the past. Second challenge is, especially if machine learning is part of a larger automated decision-making system, the automaticity and the literally what we call regulating by robot or adjudicating by algorithm, where the machine can now actually make decisions. There's lots of uses in government where this technology can be applied that I think will not even rise to the level of any judicial review. And so at the outset, I should note that the courts get involved in reviewing federal agency action only when there is, quote, law to apply, or when there is not agency action that's committed to agency discretion by law. So, for example, handwriting analysis at the Postal Service is not something that's going to give rise to judicial review, but neither, quite frankly, will be the IRS's use of this to identify potential taxpayers to audit, or the Occupational Safety and Health Administration using this as a tool to identify which facilities to inspect for compliance with workplace health and safety laws. In fact, one project with my colleague Adam Finkel and Richard Burke that they have done as part of a larger initiative we have at the Penn Program on Regulation, they have used some machine learning algorithms to look at how OSHA can improve its targeting of facilities, and they find that OSHA, if they used machine learning algorithms and combined, all they did was combine publicly available financial data, publicly available OSHA enforcement data, and publicly available EPA enforcement data, and nevertheless could improve the targeting of facilities that had workplace accidents by 30%, which is a significant improvement when you're thinking about something as vital as workers' life and safety. So I think when you have these kinds of decisions that are committed to agency discretion by law, and by the way, that's the Supreme Court has determined that in a case called Heckler versus Cheney, that agencies' decisions of who to enforce subject to enforcement, and who not to subject to enforcement, who to inspect, who not to inspect, that's committed to agency discretion by law. So I think there's a lot of uses in supporting the targeting, for example, of enforcement resources. It's just not going to really give rise to litigation. There's really no real barrier there. There's also probably very little legal risk, relatively legal risk, when machine learning would be used to support decisions compared with if it's part of an automatic system to replace human decision making. That becomes probably more legally problematic, or at least it implicates the kind of principles that I'm going to talk about here today more than if it's just like anything else, something the decision maker consults, but then humans are still basing it. It's one input into a decision as to the sole device. Now, I think we can imagine a world increasingly where we get much closer to the machine learning algorithms and the automatic systems making the decisions than just providing the input to them. Could imagine, for example, rethinking how we determine whether pilots can renew their pilot licenses. Right now, one of the characteristics or qualities that a pilot has to meet is an age limitation. It's a crude rule that you are above a certain age, you can no longer renew a commercial airline pilot. You can age out. One could imagine reconceiving the way we license pilots so that it's not rule-based but algorithm-based, and that the algorithm makes a forecast of the safety risk of this individual pilot based upon its characteristics, and that's how the adjudications of who gets a pilot license are made. That would be an example of adjudicating by algorithm. Or you could even imagine, I think, and maybe by the way, you all know of examples of this where we don't even have to imagine, but where machine learning could be setting the rules itself if it's part of, say, an agent-based modeling system where various rule formulations are tested out, and the algorithm actually picks, in some sense, the one that optimizes on the objective functions that are determined ahead of time by the regulator. That maybe is partly what is happening in a very simple, maybe banal example where the city of Los Angeles has installed sensors in all of its streets and has a system that determines when traffic lights turn red or green based upon a black box algorithm. It seems pretty simple and ordinary, but when you think about it, that red light is a rule for anybody who's going down a street at a certain time. And you could imagine maybe in high-speed systems, high-speed securities trading markets, for example, where rules might need to adapt or change at time, and you need to have automated equivalents of a green light, red light system. So I'm going to talk more about the legal challenges in these settings where there would be much more determination, maybe complete determination by an algorithm-based system, either in adjudicatory context or in setting rules, because I think those are the more challenging ones that will raise the kinds of administrative law doctrines that I'm going to talk about the most. I'm going to talk about 4 doctrines. First, what's called the non-delegation doctrine, then due process, then anti-discrimination or equal protection, and finally various transparency requirements. These are 4 major doctrines that form the backbone of any, for example, administrative or constitutional law course in a law school setting, and they're ones that arguably are implicated by the applications of machine learning in the federal government, which is my focus here. So first, let me just talk a bit. I'll just go through these very briefly, each of them in turn. First, the non-delegation doctrine, which derives from the U.S. Constitution's grant of all legislative powers being vested in a Congress in Article 1 of the U.S. Constitution. Now, some folks like Stanford Law professor and California Supreme Court Justice Tino Cuellar has written a paper in which he says that we may be entering a world of cyber delegation, where legislative powers are no longer vested in Congress. They're not even vested in an administrative agency, which is where the usual concern about delegation arises when Congress gives some power to an agency, but now it's going to some kind of robot, proverbial robot here. The standard non-delegation doctrine hasn't actually, in fact, been used an awful lot. Some would say it had only one good year during the New Deal when the Supreme Court struck down the National Industrial Recovery Act, for example, on non-delegation grounds. but the basic contours of the doctrine, it's still alive, is that when Congress does delegate authority to the Department of Transportation or to the IRS, that delegation of authority to create rules and to adjudicate disputes and settle people's rights, that delegation has to be accompanied by an intelligible principle. Now, when you look over the sweep of the kinds of principles that have been approved by the court over the years, protect the public health with a adequate margin of safety, that's sufficiently intelligible. Even regulate in the public interest has been viewed as intelligible. I think it's fair to say that really any objective function that's embedded in a machine learning algorithm has to be much more precise and intelligible than those. So I don't think this will necessarily serve as a huge barrier. Now, there is an associated doctrine called the private non-delegation doctrine that the courts have been much more consistent and have invoked from time to time, a little bit more frequently, that prohibits the government from delegating governmental functions to private entities. And if you think that it's impermissible for federal regulatory decisions to be shifted out and outsourced to the private sector, well, maybe then, especially when a lot of the machine learning algorithm work is probably done by consultants to the government, is this an impermissible private delegation? Well, I think the reasons for the private non-delegation doctrine really don't fit here. The worry is that if the regulatory authority is given over to private actors, that they're conflicted. They have interests at odds with other people. They're not acting in the public interest, but in the private interest. Algorithms are not going to have that kind of inherent conflict of interest. Now and the objective functions and the way they're structured and the assumptions underlying them can be scrutinized. Again, to see if there's that intelligible principle, and of course whether that principle lines up with the statutory objectives of the government. The other thing is that even though we're thinking about a context in which decision making might be operationally handled by an algorithm, obviously humans still control and define and shape that algorithm, and ultimately could even pull the plug on it. So I don't think that is the idea that this is shifting the locus of decision making away from humans really exists when you take into account that factor. Lastly, I just mentioned there is some Supreme Court precedent that approves the delegation or the granting of functions, at least, over to private companies. There's a case called Prometheus Radio versus the Federal Communications Commission, which involved a challenge to the Arbitron company doing ratings of television shows and audience analysis, and that providing the key input into the Federal Communications Commission's decisions about TV and radio licenses. And the Supreme Court there said that Arbitron is really just a measurement device, and that it seems to me is a very clear precedent that one could look to for the use of machine learning. That this is an instrument. It is there's a reason it's called machine learning, I guess, and that should be just as permissible, at least, as the use of Arbitron. So that's the non-delegation doctrine. Let me turn to the due process clause. This is a requirement that governments provide a fair hearing and a neutral decision maker and an opportunity to be heard before people's rights are affected. And actually, it's now rights or interests. In a case with Goldberg versus Kelly, the Supreme Court in the 70s decided that welfare recipients couldn't have state welfare recipients couldn't have their benefits terminated unless they were given a hearing before their benefits were taken away. And that decision was important because welfare benefits are nothing that somebody has a right to, but they obviously have a very deep-seated interest in it. Interestingly enough, the canonical case for the due process analysis that federal agencies have to go through came about a few years after Goldberg versus Kelly in a case called Matthews v. Eldridge, in which the issue was again government benefits, but here it was federal disability benefits under the Social Security program. And in that case, the Supreme Court said that it is okay to halt those disability benefits without a hearing up front. So completely different than Goldberg versus Kelly. And the reasoning is very important in that case because Matthews v. Eldridge establishes a three-part balancing test that the courts have applied ever since, are supposed to apply, in determining whether a particular procedural arrangement does or does not comport with due process. And the court there said the balancing should be first to look at the private interest at stake, okay, so that the more serious and significant the private interest, that's going to mean that the government presumably has to do more. But then also, secondly, look at the risk of an erroneous deprivation of that interest, so the risk of error from the process that's being analyzed. And then the third would be to consider the government costs or the administrative burdens associated with different procedural arrangements. So if we're going to take a look, and obviously all of this analysis that I'm talking about here is sort of in the abstract, and a lot will depend on the actual machine learning applications and the way the algorithmic adjudication is structured. But I think it's fair to say, generally speaking, that the first of these variables, the private interest at stake, is exogenous to the algorithm, right? That will be what it will be. With respect to the other two variables, I'm going to take the third one first. I think it's easiest. In terms of the cost to the government, going toward a machine learning or algorithmic approach has the potential to really save a lot of costs of human decision making. So I think that weighs in favor of this. So the real pivotal one might be the second one with respect to error. We could compute some error rates for machine learning, and that actually is a much easier way to validate the algorithm than validating a lot of human adjudicatory proceedings. But typically what is done in the due process context when we're looking at different procedural arrangements for administrative processes is to look at the rates of reversals of decisions on appeal. So how often are things reversed on appeal? And if you think about these as error rates, you can start to see what kind of range might be acceptable. The Matthews v. Eldridge case, actually there was an error rate there of 3.3%, and the court said that's sufficiently low. There's another Supreme Court decision, 4.4%, sufficiently low. Other cases say it's definitely too high to be at the 50% or 75% error rate. Somewhere in the middle, between those, courts tend to go either way. So there's some cases that say 30% is too much, but 20% is okay. But another case that says 12% is too much. I think the thrust of machine learning is to improve accuracy, and if it really is doing so in a meaningful way, then and if you can compute error rates for the algorithm, maybe in the 5% range, you're probably going to be fine, I think, in sustaining the use of these on any due process challenge. That would be, generally speaking, my assessment there. Let me move to probably the two remaining ones, which may be the more interesting and and perhaps challenging ones. When it comes to the third one, equal protection or anti-discrimination, I think we can put aside whether there's any animus or clear discriminatory intent behind the use of an algorithm. If there is, then that will clearly offend anti-discrimination principles. But when it comes to assessing the federal government's use of algorithms on equal protection grounds, the Equal Protection Clause is in the 14th Amendment, which applies directly to the states. The equal protection requirement that the federal government has to meet is a requirement that's incorporated through the Fifth Amendment's Due Process Clause, which does apply to the federal government. And at the federal level, in Washington v. Davis in the mid-'70s, the test on equal protection is that you have to show something more than disproportionate impact. That by itself is not sufficient to show a discriminatory intent. But the way the Equal Protection Clause analysis typically lays out is that if there is some suspect classification that is being made by the government, some classification of people by a suspect class, race, religion, for example. Gender is somewhat in a quasi-suspect category, but these classes, these protected classes, if the government's classifying based upon them, then the policy that contains that suspect classification must be subject to heightened scrutiny, strict scrutiny, which typically is thought to be really strict. Some people even say it's strict in theory, but it's fatal in fact. If it doesn't involve a suspect classification, the only thing that Equal Protection Clause analysis requires is rational basis review, which is very easy. As long as the government has some reason for what it's doing, then it will be upheld. So a pivotal point here is to figure out in Equal Protection Clause analysis, is a suspect classification at issue? And typically in the past, the clearest cases of suspect classification, the paradigmatic case would be where, say, race is the only variable into a decision-making context, and it then consistently either advantages or disadvantages the parties who are subject to those decisions. That would be definitely unconstitutional. A lot of what the court has examined since that, if you think about that as the paradigmatic case, has tended to be where a variable like race is maybe not the only variable, but where the presence or absence of a particular race becomes a categorical factor within decision making. What do I mean by categorical? So in the higher education context, the Supreme Court looked at the University of Michigan's undergraduate enrollment pattern, where people of color, applicants of color, were categorically given automatically, just based on race, a 20-point advantage in a score for admissions purposes. In the law school case involving the University of Michigan, they didn't have that clear numeric score, but they consistently gave some advantage to applicants of color. In both of those cases, the court said that's suspect classification. Okay. I think it's possible to classify, or at least to use, variables related to race, religion, ethnicity, and so forth, but not necessarily to engage in classification. By classification, the courts, I think, are really looking at situations where there is some categorical difference in treatment, whether you have presence of one variable or not. With machine learning, it's non-parametric non-linear, certainly a multivariate, multivariable approach. It's complexity. It's, I think, very hard to say that race is operating, or any of these other variables are operating in the same way as it would normally be playing out in these cases where there's been a suspect classification. The concern about suspect classification in the law has been about defining someone by their membership in or not in one of these suspect classifications. Yeah?
Yeah, there's actually an interesting observation that I had regarding the subject in the machine learning context. So I spent some time, I do research on machine learning, and I teach a course here, and I have papers on machine learning. And one thing I noticed is that, for example, I trained a classifier to it from a database of New York City police officers, in which this is a stop and frisk database, in which there's like every observation is an interaction between the police officer and the citizen. And one of the variables that is available in that database is whether a person was arrested or not, conditional upon them being stopped, right? So I tried to build a model, a machine learning model, train the model, to predict whether someone will be arrested, but not use any race-based factors, right? So I used all their factors, like what corner they were on, the time of day, and so on and so forth. And I generated a model that was able to predict whether someone would be arrested based on those factors alone.
Right.
A pretty high accuracy rate, roughly 80%, right? The really interesting thing, though, that I noticed was that when I broke down the some of the other performance metrics of the machine learning algorithm, which are false positive rates and false negative rates and so on, by racial categories, the false positive rates were actually quite a bit higher for African Americans and Hispanics than they were for whites and for other groups. And so in a way, the machine learning, for whatever reason, and I don't quite know what it is in this particular case, was actually generating, from a legal perspective, I would guess, an unfair type of classification of individuals. So, like, for example, if we were to use this algorithm to arrest people, right, then it would on its face be unfair in that it would just have a higher false positive rates for one group or another. Now, the interesting thing about that is that we can't actually generate those metrics when we're talking about officers, right? Because when we compare the machine learning algorithm's performance, it's always compared against the officer themselves. Right? So the officer's decisions are actually the ground truth. Right. Whereas if we use officers, there is no other ground truth to compare the unfairness to. Right. So I was just wondering, from like a legal perspective, what kind of implications this might have, the fact that we can determine whether an algorithm is being unfair, at least with reference to human decisions, how that might play out, because it sounds like it's kind of it fits into this like forbidden legal category of discrimination. Right? So. And it's quite possible that all of these algorithms, without adjustments, will actually "quote unquote" discriminate on the basis. If we conclude that false positive rates are a form of discrimination, no matter what. So anyway, I was wondering.
Well, let me just say a couple of things. First of all, I mean, not to dismiss the import of having outcomes that are disproportionate as between people of different races. That wouldn't be enough at the federal level to find that agency use of machine learning algorithms is violating anybody's equal protection rights. The doctrine at the state level, it might well be. Okay, so we have this funny difference between, after the Washington v. Davis case, between the standards of equal protection clause analysis for federal government versus the states, where the federal government you have to really show intent. The second thing I guess I would say is that it's not surprising, right, that you might find that these kind of results might occur, even if you don't put race specifically in your data set, right? Yeah, but if you did, it's possible, isn't it, that you might actually eliminate
what's surprising
some
is
of these. It's
not surprising that it would identify a higher proportion of African Americans that would be arrested because there's a higher proportion that are arrested in the data. What's surprising is that the rate at which they would have been falsely arrested by the algorithm is higher. So in other words, if compared to the maybe I'll clarify, like if we compare the officer's decision to the machine learning algorithm, the machine learning algorithm falsely identifies African Americans to be arrested at a higher rate than it does for whites, right? So percentage-wise,
right.
So not just it doesn't arrest more African Americans.
It just more falsely arrests.
Yeah. So that's the kind of
right.
I don't know if
what's the what's your measure of the truth or
the officer,
falsity? Just the
It's
officer,
always
right?
I guess the officer,
right.
The officer's decision to
right.
The officer's decision to arrest. Yeah.
Right.
Yeah.
Right.
Yeah.
Which you wonder that may already be biased in favor of a false, right? So if it's even worse than that, I think the upshot actually from where I'm at on this is that I don't think that necessarily gives rise to an equal protection clause problem at the federal level at least, but it doesn't mean it doesn't give rise to a problem. And one way I want to come out on this, especially on concerns about equality, equal treatment, and about transparency, where I think there's another important challenge, legal challenge for machine learning to kind of encounter is how do you square that with our prevailing law that requires reasons for decisions? I think that, again, as with the equal protection clause analysis on transparency grounds, it's possible, I think, to look at machine learning and say, no, this, the way the law exists right now with respect to reason giving in the regulatory context, at least, is that you must disclose assumptions and methodology, and you can do that about your algorithm, right? And you have a Supreme Court decision in 1983 that says when courts are reviewing the expert judgments of administrative agencies on scientific matters, that's when the courts must be at their most deferential. So I think that there are, the barriers to using this on legal grounds are much smaller. The question is, and I guess this is where I conclude, would be just because current law probably allows agencies to use this a lot more than it does, doesn't mean that the policy concerns or considerations underlying some of these doctrines might still be worth investigating. And it's also possible, of course, that the law may change on this. So our way of thinking about equal protection clause analysis is grounded on a world in which we didn't have these kinds of tools. We had, basically linear thinking in our statistics as well as is in our law. So that all could change. I do think you're exactly right to say that we really ought to think about how the use of algorithmic systems compare with human systems. I think that it's unfortunate there's a fair amount of opposition to thinking, at least entertaining the possibility of using algorithms simply because they're scary and they're non-human. My view is that these applications should be carefully assessed, just like any new innovation should be carefully assessed, but not against some state of perfection, but against what is already algorithmic decision making. Either the algorithms are in the human mind or they're in the rules and processes of the administrative state itself. And we should be thinking about not algorithms versus perfection, but algorithms versus human algorithms. A final thought, though, about this, and I think maybe the biggest challenge, and we really don't address this here, and it's not necessarily so much a legal barrier, but it is, I think, a very important practical barrier to the application of algorithms in the governmental context. and that is that I don't think in a lot of domains of the law we have very carefully and precisely specified value priorities and how trade-offs should be made. And I think to use algorithms, we need to be much more precise about this. But the law has allowed us to engage in what Cass Sunstein calls incompletely theorized agreements. We don't necessarily decide how much safety there should be, but we say there should be a reasonable amount of safety. We have these standards that are spongy and allow us to solve disputes in a way that's practical. I guess it gets us through, especially in a world that's divided in a lot of ways and where there are value conflicts. We can paper some of those over, and we do paper them over, I think, right now. And that may be, more than anything else, the biggest barrier, I think, to widespread adoption of at least the kind of automated uses of algorithms that I talk about. So let me just stop there and entertain other questions and comments and reactions. I would be very grateful to learn from all of you.
So I totally buy your argument that there shouldn't be a per se problem with the use of machine learning algorithms here. But obviously there's a lot of questions about how they're used, right, which would go to some of these questions. Right? So with respect to private non-delegation, there are different roles that government could play vis-a-vis some technical expert consultant, right? In one limit, the government agency just says, consultant, you figure it out. We want to make decision X, right? And on the other hand, the government agency could be more in the driver's seat, right? So it seems like there's somewhere in between, you draw a line and say, no, this is too much delegation, right? Similarly with issues around transparency and due process, it seems like there's a lot of details that will need to be filled in about sort of how to go about being transparent enough, providing enough explanation, or even what the goal is of seeking an explanation, right? Are we looking for a public reason that justifies a choice, or are we looking to explain why in some sort of scientific causal sense we got a particular result? And I'm really interested sort of in the challenge of figuring out how to go into the nuts and bolts of how agencies can responsibly use machine learning. It strikes me that your sort of breakdown of where the legal lines lie is a pretty useful taxonomy for purposes of understanding, sort of organizing that discussion. Right, here are the responsibilities that an agency has under the law, and here are the lines they're clear of. Now, what does that mean? What is the cookbook they can follow to actually be both responsible, but also within the lines that the law allows?
I think that's exactly right. I would agree with you. Obviously, it could be used in ways that, if you're not careful, and I hope that the message of this should be not, green light, do anything goes, but if you do it carefully and if you think it through, there's no insurmountable barrier here. And as to the, what will be the responsible practices or might be the best practices, I mean, I think we're really just at the beginning stages of that.
That's right.
Yeah.
That's right. And there's people working on these issues coming from a technical direction to try to understand how can you measure and predict issues of bias.
Right.
What can you do in the design of algorithms to make them more resistant to certain forms of bias? What do you do if you know you're starting with data about police officer actions where you suspect bias to start with?
Right.
And so on. And there's been some interesting progress in that area. And I think the task of sort of connecting that work to the work that's done in the law and policy space is really valuable, but also kind of difficult to do.
Yeah, it may be difficult to do until we start to see uses that are more uses first of all, and then we start to see them actually having some consequences.
And one that's gotten a lot of attention is the use of risk prediction in criminal
right.
Right, where there have been both some fairly interesting studies as well as some sort of cautionary tales
Right.
from practice.
Right.
And those are also, obviously, that's a case where the due process concern is at its strongest when you're talking about imprisoning someone.
Right, and there you also have a private delegation, right? I mean, does anybody really know much about the algorithm underlying the?
Not as much as one would like.
Yeah.
Yeah. You would think I would have thought for an application like that something close to full transparency about the nature of the algorithm would have been indicated, but that apparently has not been the case.
No, that's right. Yeah.
It's super interesting, all the things that came up, and I'm just curious whether there is anyone or any agency that's actually trying to consider these questions within the U.S. government. And then I had a second question, which I've now forgotten.
Well, the answer to the first question is, in the last administration, we had an Office of Science and Technology Policy, which we don't have anymore. And that was a leadership agency looking at those sorts of issues. I think, in some ways, Ed should speak to this as well, but a lot of interesting folks at the state and local government level. The city of Chicago, for example, I think has at least some folks working on and thinking about these issues as well. Yeah, and I should maybe give a plug. I mean, if anybody's interested in some of these issues, we do have a project that we have run at Penn called Optimizing Government. You can go to the website for it, and we've got not only a whole collection of papers, but we had a series of workshops that are online, and you can find out more there.
And I'm just curious if there are any sort of broad guidelines on the procurement of algorithms in the government.
And I think nothing that's distinctive that I'm aware of to say outside of what would be the normal procurement guidelines for hiring any outside consultant. And I should say that one of the reasons why I think that there really shouldn't be any insurmountable barrier to the greater adoption of machine learning if used responsibly, is that there have been parallel or examples, uses of other kinds of advanced mathematical techniques and that the courts have actually examined and have essentially blessed. So this is obviously there's some qualitative differences here, but this shouldn't be necessarily as as distinctive or it's not a sui generis situation, as we would say. Yeah.
Based on are states and local governments automatically better test beds for using machine learning here, based off of the fact that you sort of were talking about inequality and discrimination, and that intent is not really something that under the current law that states sort of looked into.
Well, if you can ever show that somebody has discriminatory intent, state or federal level, that's an Equal Protection Clause violation. The challenge is just that, most of the time people aren't trumpeting around on the campaign trail that they're antagonistic toward people of a certain race or religion, for example. Sometimes I guess that does happen, but so that gives, in some sense, the federal government, I think, a little bit more room on the equal protection side to work with this, whereas at the state and local level, I think particularly it may be grounded a little bit in our historical tradition where we had variation across states in the official policies that were discriminatory, that there was a concern that we could eliminate those official policies but still have disparate impacts, and that so the state at the state level, just finding disparate impacts can suffice to demonstrate intent or to demonstrate an equal protection violation. So I guess you could say that if you can solve the equal protection problems at the state or local level, then by a fortiori you should be fine at the federal level too. So in that sense, it would be a good, a more stringent challenge, to be sure. Yeah. But again, when you find disparate impacts, the question is it more or less than what we might already have? We don't have, I don't think anybody would say we have a system that's free of disparate impacts based upon suspect classifications.
So we'll just wrap up, and if no one has any additional
Great.
questions.
Well, thank you again for the opportunity, and thank you to Todd for arranging all of this, and Todd and Reeve for the opportunity to work with them and to learn about what they're doing at the administrative conference. Thank you.
Thank you.
You had asked about procurement. This is not directly related to the question, but
Hey, how are you? Thank you again.
Yeah, no, my pleasure. Yeah, really fascinating work that you're doing. I mean, I think I'm doing work on this. I'm doing work along these lines. I've actually been thinking through. So, did you know the Journal for Public Administration Research? So there's a symposium piece that I'm doing.
Oh, really?
You know Andy Whitford? Yeah. So University of Georgia. Yeah. We're doing it together on work, and the piece is called "The Promise and Perils of Machine Learning for Public Administration Research and Theory."
Okay.
And so we're thinking through some of these implications of machine learning for, for both the practice of research in public administration and also what it implies for, agencies themselves and the administrative state. And so it's too bad that, I was just reading about the optimizing government seminar, so it's looks really fascinating.
Well, maybe we should have you down to talk about that paper.
Yeah, that would be really
I can
awesome.
give you
A copy of that.
Oh, sure, that'd be great. Thank you so much. Yeah. This paper is really fascinating. I really like the way that you kind of think about machine learning in a legal context. It's I think that's exactly the kind of thing that I was looking for.
Impact assessment, definitely.
One question I actually had, just from your perspective and through some work in this area, was the following. Now, I teach machine learning here, and
it's
I
basically
have the
applied
students do a little exercise, right? And the exercise is the following. There's a bunch of H-1B visa data that's available on my web, right? And so one of the most important decisions that exists within that data set is whether H-1B visas are
far more comprehensive.
So I tell students, okay, let's take a simple algorithm and let's try to predict whether
they were definitely for innovator,
whether we can
sort of
accurately determine if an H-1B visa can be certified based on data. So use a machine learning algorithm to predict, right? Certification, visa certification. And as it turns out, you can do it for. You could actually do it with very few variables. You have 80%, 90% accuracy, which is fascinating. So in other words, all of the expertise of the bureaucrats who make these decisions on the basis of the application can be, it could be accomplished with this, right? So that kind of thinking,